My name is Doug McManamy. I'm an attorney with McManamy Jackson Hollis here in Savannah.
And I'm TJ Hollis, an attorney with McManamy Jackson Hollis here in Savannah.
Can you expand on family bankruptcy and divorce?
So that is primarily on the seller side. And on the family sale issue, if it's a brother, a sister, and two cousins that own the property, they all have to sign off on the paperwork that we need at closing. And they all have to be in agreement. It's not uncommon for one of those four to sign the contract and the other three, to varying degrees, have some information about it. It's important that if you want to sell that property, you know ahead of time before you enter into the contract who needs to be the signer for the seller. We encourage people to call us before they even sign the contract, and we can check to make sure we need Aunt Esther, Uncle Joe, your cousin Billy, and your Aunt Susan. And so that we've accounted for everyone. And then the other part is agreement. We can't change family dynamic, but we can try and help the process of the family dynamic getting to the goal of selling the property. In terms of bankruptcy and divorce, a person in bankruptcy can sell property, but the bankruptcy court and the trustee have to approve that. So if a person is in bankruptcy, we need to know that ahead of time. And then we work with them, their bankruptcy attorney, and the bankruptcy court to get the necessary approvals in place. Because that is not something that you tell us on a Wednesday so that we can have it done for a Thursday closing, because there's certain court filings that have to be made and so forth. In terms of divorce, if a seller is going through a divorce, we need to know that. We need to know, has it been filed? And if so, we need to make contact with the divorce attorneys. And then we have to have the written agreement between the two spouses on how are we to treat the money that is going to be generated in proceeds from this home sale. Sometimes there's an agreement, it's 50-50, 60-40, whatever the case may be. You're going to cover this expense and then we'll split the balance. Sometimes the parties haven't agreed, but because we have enough lead time, we can work with the divorce attorneys, and we can make arrangements for the proceeds to be deposited with the court, maybe to be set up in a separate escrow account for the parties so that they can work out their divorce differences. But the house has already been sold, the money's sitting there waiting for everyone to come to terms on how they're going to split that.